All right, let's proceed.
May it please the Court. Chief Justice Ireland, members of the Court. My name is Michael Aylward. I speak today on behalf of the defendants, Our House East and its owners and trustees, who face a judgment for $9 million for a wrongful death in a case where the jury found that they did not cause that wrongful death. This case went to trial in 2010. The judge had reserved the 93A count. The issues that went to trial were negligence, willful liability, wrongful death. Before trial, the court dismissed the strict liability claim on the grounds that it was preempted by Chapter 229, Section 2. She declined to grant a similar directed verdict motion for 93A. After 2 weeks, the jury found that although there was negligence, that negligence did not cause the death of Jacob Freeman. They granted a verdict for the defendants through special questions on each and every tort count before them. Immediately after this verdict on November 5th, the defendants filed an emergency motion for a directed verdict on the 93A claims. That motion was denied. 3 months later, Judge Fahey found, contrary to what the jury had ruled, that in fact there was causation, that the violation of the building code did cause the death of Jacob Freeman, and furthermore, that that violation was willful. She rendered a verdict for approximately $7 million in treble damages and another $2 million plus costs for a total of about $9 million. In our brief, we've identified 9 separate errors that we believe independently warrant reversal. Today, I'd like to focus on the 2 that I think are of transcendent importance, not only with respect to this case, but with respect to the future prosecution of wrongful death claims in this Commonwealth. This court has repeatedly found that Chapter 229, Section 2, the Wrongful Death Act, is the single vehicle, the special remedy for wrongful death claims in this Commonwealth. What this court ruled on Hallett has equal application to this case. A plaintiff may not choose between alternative remedies of the Wrongful Death Act on the one hand and Chapter 93A on the other hand, as it may suit the estate of the plaintiff. And yet that's exactly what the plaintiffs did in this case. Now, Chapter 93 was enacted in 1967 as a gap.
Can I ask you how this works, though? So you have 229.2, which allows there to be a suit if the deceased could have recovered damages for personal injuries, if his death has not resulted. Maybe I'm reading that wrong, but let's say there was not a wrongful death claim here, but it's just a 93A claim. Same facts, just a 93A claim. What would you say? 93A claim doesn't survive the death, or 93A claim would how would that play out?
If you're, as I understand your question, Justice Cordy, this is just a personal injury case, not a death claim.
Right. Right. He was
which event,
very badly injured, but
yes,
not
This court
killed.
has already ruled in Mallet that personal injury claims can be brought under 93A, subject to the requirement that the injury result from a deceptive act in trade or commerce.
Let's assume it is for the moment. Let's assume that we agree that maybe it is here. But so how does this play out?
To the extent that there is a consumer protection injury aspect of the personal injury action, it is recoverable under 93A. They don't get a double recovery. This court's ruling in Klairmont is clear on that. To the extent that there...
Could there be a loss of consortium claim under 93A for...
If there was a type of damage recoverable under 93A that isn't recoverable commonly under the tort law, that's the very kind of thing that 93A has been allowed to result in. It's an additional remedy, not an alternative remedy. What's troubling about this case is that it was treated as an alternative remedy. If you look at...
Again, I apologize for my ignorance here of how 229, 2, and 93A or other claims might intersect in these circumstances. But so 93A claim, individual severely injured. Parents of individual claiming loss of consortium, loss of comfort, et cetera. The person is very badly injured. Could they bring a claim under 93A?
Not if it was a death case.
But if it was not a death case, they could, saying they were also injured by the fact that their son or daughter was seriously injured by a violation of 93A?
The way it would work in that circumstance is that the personal injury case would go forward. there would be a jury finding with respect to liability and damages in the personal injury case, and the court would then address what remains of the case on the 93A claim. We believe that the court would be guided by the jury's factual findings on liability. If in this case there was a finding of no liability, then we also believe there would be no liability under 93A. But hypothetically, if the jury had found liability on a negligence count, the judge could award additional damages under 93A if the requirements were otherwise made that were not otherwise recoverable under conventional tort law.
But a pure 93A claim would not involve, I take it, the kind of damages we're talking about here.
The damages awarded here were exactly those being sought under the wrongful death statute. That's the whole point.
But I think the question is, forget the wrongful death for a second, let's say Jacob Freeman were 5 years old and was very badly injured. Could his parents forget the tort, just bring a 93A on the same facts, and recover loss of consortium under 93A when the child is the one injured?
I don't believe so, Your Honor. I think that would be properly recoverable under the tort remedy. As this court ruled in Linthicum, 93A is supposed to be an additional remedy, not an alternative one. There may be tactical reasons why, as in this case, the plaintiff would want to plead his case to the judge and not to a jury.
Well, you also might have a statute of limitations problem.
I'm sorry, Your Honor.
You also might have a statute of limitations problem. You didn't bring it within 3 years, but you got it within 4.
That could also be the case.
Does it depend on the kind of injury? For instance, if it were a product liability case, that a defective automobile and the manufacturer of the automobile, or if it was used, let's say the manufacturer of the automobile knew that there was a recall problem, didn't recall the thing, and a 5-year-old child was severely injured. 93A available?
Yeah.
Unfair and deceptive practice?
Again, if it arose out of trade or commerce and was caused by an unfair or deceptive practice, yes. I mean, that's the holding in Maillet.
So back to Justice Corey's questions. If you could bring this, if one could bring this action if Jacob Freeman were alive, and doesn't 229 say that, just as he said, that you can, the representatives of the estate can sue for what the decedent could have sued for, correct?
Except that the suit that they're bringing was for wrongful death damages. And
right.
the damages that they're awarded were for loss of support and loss of consortium.
That goes to your
That's not a consumer protection injury. The damages that are being claimed are not a claim by consumers. The parents were suing as the administrators of the estate of Jacob Freeman. They were not suing for 93A damages. They were suing for wrongful death damages. Those are the damages the jury declined to give them. Had there been a very different claim involving a different aspect of damages not recoverable under the Wrongful Death Act or the tort claims, then I could see the argument. But the point, I mean, even Judge Fahey in her opinion on 93A starts, this is a wrongful death action. It was not a consumer protection action, and the damages they were seeking were the very damages that this court has ruled are only available under Chapter 229, Section 2. That's the point. There was a complete identity, not only on the facts, but on the damages that were being claimed on the two statutes. The legislature can't have intended, when it enacted 93A, to entirely supplant more narrowly drafted regimes that apply to things like wrongful death. I mean, that's essentially what this court ruled in Darvirus, when you held that where a claim was properly styled under the Medical Malpractice Act, it made no sense at all to allow an alternative remedy under Chapter 93A. Chapter 93A is a gap-filling statute. It created remedies where none existed before. It is clearly sui generis, but it doesn't supplant the existing law. Where you have a statute that's been on the books since, I believe, the 1840s, remedying wrongful death claims, why would we suppose the legislature would do away with the procedures and limitations set forth in that cause of action when it enacted Chapter 93A for consumer protection violations? It doesn't make sense as a matter of statute. It doesn't make sense as a matter of public policy.
Now, I thought you had said that if this were a case in which a person goes to a restaurant or receives assurance that there's no peanuts in the food, and that turns out to be a false and fraudulent statement, that they would have a 93A remedy as well as wrongful death.
Not in the Your Honor is thinking of our part of the brief discussing the scope of 93A, not in the context of wrongful death claims. What we were arguing there was that in this case, Mr. Freeman comes into the bar to get a drink. He does not come into the bar to test the stairs. You could think hypothetically of a circumstance such as the one you just described, where there's a chili eating contest, or someone is assured by the waiter there are no peanuts in the satay sauce, and yet there are, and the person suffers injury. What we were suggesting there is that that's the kind of deceptive practice that would give rise to a claim for 93A liability in the context of a restaurant, in the context of an unfair deceptive practice, as opposed to here, where the court ruled that it was the violation of the building code that was the unfair deceptive practice and met the trade or commerce requirement of Chapter 93A.
But so, to take that example, if the person who ate the peanuts in the satay sauce died, could the representatives of her estate raise a claim under 93A rather than willful and wanton under 229(1)?
No, because the legislature has made a conscious policy choice that claims for death should be brought under Chapter 229, Section 2.
Procedurally, isn't it? Procedurally, they need to be brought under that?
It's more than that, Your Honor. It's that we have a specific statute that's been on the books for nearly 200 years dealing specifically with death claims. The mere fact that there's a consumer protection aspect to it doesn't change the whole regulatory or statutory regime applicable to it. If so, you'd have terrible confusion in terms of statutes limitation, burdens of proof, identity of parties.
No, I'm going to assume that all those kinds of issues remain the same because, as you say, this is the procedure by which you bring this action. So they made the statute of limitation, they've got the right parties, but this is a substantive cause of action that the decedent could have brought if he or she had lived.
And my response is that we have a statute that provides for death claims. It doesn't deal with injury. Where the injury becomes a death claim, the action is properly brought under Chapter 229. The point is, that's exactly what the plaintiffs did in this case. This is not like some of the other actions where there's an issue as to whether, having brought a claim under a different statute, they might have brought it under Chapter 229. They sued for these damages that they ultimately received under the Wrongful Death Act, and they lost. What policy sense does it make to allow a plaintiff 2 bites of the apple, to try their claims in front of a jury, lose, and then hope there's another judge that will be more sympathetic than the jurors were?
That happens all the time with common law claims being coupled with 93A claims.
But not, Justice Gantz, where there's an identical factual issue. If you look at the case law that is cited by the plaintiffs, they all involve situations, I think with one exception, where there's a different standard of liability or where the evidence was different. We were unable to identify any case where there was a common element of causation as there was here. There was no difference in terms of the evidence or the facts. They simply reached different conclusions. 11 jurors concluded that the problem with the building code did not cause Jacob Freeman's injuries.
Isn't that in the, what's the appeals court case that you rely on so heavily? Or the Justice Granger's concurring opinion?
Elastometrics.
Yes. Well, isn't that exactly what happened there?
And it's the reason that Justice Granger wrote the concurring opinion.
Yes, it is, but my point is...
There are 2 cases, Veleca and elastometrics. Those are the only 2 of the legion of cases.
But he agreed with the majority that our case law required the result that the majority reached, correct?
As the appeals court would be required to. This court has never ruled that way. It is not required to follow a rule of practice in the appeals court. As we've urged this court, we feel that there are significant constitutional considerations that were not considered in elastometrics, were not considered in Veleca. And really, there's one, I think, Bunnell, that briefly touches on it in a single sentence, and yet that cry out for a reversal in this case. That this notion that this right to a trial by jury that we hold sacred in Article 15 can be eviscerated through the action of a single judge, that 11 jurors can hear evidence, weigh the credibility of a former employee who claimed that there were 50 customers a night crowding into the space that's a little bigger than where I'm standing now, It's hard to believe that they'd be standing in this little space making a quiet cell phone call. It's sort of like doing it on the Green Line at rush hour. But that 11 jurors could hear that evidence and decide that there was no credibility there, but a judge would take that all away. We believe that's the Article 15 problem, and that issue was never considered in Elastometrics or Valeca or any of the other cases.
I don't think you raised it below either, did you?
Yes, we did.
You did raise it
Well,
below.
here's what happened, Justice Cordy.
Oh, that's all right.
There was no separate proceeding.
Okay.
The plaintiffs, the minute the jury verdict came down, moved for directed verdict. Their argument of waiver is we didn't use the word, quote, constitutional. We simply said, Judge Fahey, you must follow what the jury has found. Apparently, if we'd used the word constitutional, there wouldn't be a waiver.
I interrupted you early in your argument. You said there were two most important errors. Have you covered both of them?
Essentially. The first would be that we believe that the wrongful death statute is the exclusive remedy. Mm-hmm. The second is that we believe that the manner in which the court dealt with the 93A claims unconstitutionally interfered with the right to a trial by jury. We're not suggesting there's a right to a trial by jury in the 93A claims. We're simply saying that in the manner in which the Superior Court judges dispose of 93A claims, they may not, in effect, nullify what the jury has found. There is a remedy for that. I mean, if the judge truly believes that the jury got it wrong, we have Rule 59. They could have moved. It's tellingly that they didn't in this case. Had they, it might have been a different story.
Thank you.
Thank you.
Thank you.
Good morning. Joseph Sano on behalf of the plaintiffs, Michael Freeman and Lisa Klairmont, the parents of Jacob Freeman, a 21-year-old college student who died on April 1st, 2007. With me are Thomas Elcock and Jeffrey Newman. I'll be addressing 3 points today. First, that 93A applies to personal injuries in this context. It doesn't abate at death. And applying the substantive law of 93A liability under the wrongful death statute is appropriate, and of course it's exactly what happened here.
Let me go back to the question I asked earlier. Let's assume that you just brought a 93A action. No wrongful death, no negligence, just a 93A action.
Certainly.
Could you recover in that 93A action loss of consortium, third-party recovery, loss of consortium, and loss of support?
Certainly. The 93A remedy provides for redress, for a compensable remedy for all harms that flow from the unfair and deceptive acts.
Even to individuals other than the consumer?
I would submit that that is correct.
So have you ever seen a 93A claim in which loss of consortium damages were awarded to third parties? Third parties.
I don't have personal experience with that circumstance, but the legislative remedy is for the injury to be rectified, and so it would encompass all of the remedies available at law. And we submit, Your Honor, that what you have here is a situation where, accepting that 93A applies to personal injuries, then the question is, what are the damages that flow from that? And in this context, if we look at the survival statute and the wrongful death statute, we can see that they work in tandem. That under the survival statute...
Well, under the wrongful death statute, you can bring an action that the deceased could have brought for personal injuries if the person, the defendant, by willful, wanton, or reckless conduct or acts causes the death. Right?
That's correct.
And that's exactly the issue the jury decided that it didn't.
The jury decided the negligence claim, and they decided the gross negligence claim. What they didn't decide, what was never presented to the jury, was whether the conduct of the defendants was unfair and deceptive, and whether that conduct...
But I think but can't you only bring that action in this context if there has been a willful, wanton, or reckless act that causes the death? I'm confused about how 93A plays into 229. It
Certainly.
says you can bring these
Let me address that.
If the deceased could have brought the cause of action, then it can be brought in his name, but only if it's caused by the willful, wanton act.
Well, it could be brought under negligence. But I think we need to take a step back.
Or negligence, yes, of course.
I think we need to take, and there are other circumstances as well, but we need to take a step back. Beginning with Gaudet, this court, a number of years ago, a number of decades ago, determined that the issue that the Commonwealth had been operating for more than 100 years under a fallacy, that without a statute, there'd be no right of recovery for an injury resulting in death. And essentially, that case changed the law and recognized, no, we've been operating this issue that Lord Ellenborough decided more than 100 years ago was a fallacy. In fact, the common law recognized injuries involving wrongful death. And in the context of the Matsuyama case, this court adopted a brand new cause of action for lost chance of survivability. It's not even a wrongful death claim, but as long as the elements that were identified by this court in Matsuyama and Gaudet are followed, that is, that the degree of culpability is an issue, that you follow the procedures of the wrongful death statute in terms of who can sue, and follow the other procedures of the statute, which, of course, the statute creates no independent jury trial right under the terms of the wrongful death statute. It simply provides a procedural mechanism for the law of this Commonwealth. The substantive law, in terms of the basis for the claim, can come from anywhere.
So what you're suggesting, let me just make sure I'm clear on this, that you didn't have to bring an action under 229 Section 2 to recover the damages you did. You just could have brought a 93A claim, and that would have been enough.
No.
Not correct. We brought a 93A claim using the wrongful death statute. The
And
judge
you say you would
evaluated.
have to do that. You had to do that.
We had to, absolutely. We're not suggesting otherwise.
But it says you can recover if there's been a willful, wanton, or reckless act that causes the death. That's how you recover under 229 Section 2.
It's not a substantive limitation, and in fact, we have this circumstance here. There was a finding of a willful.
Not by the jury.
No.
The jury decided that very point, didn't they?
By the judge under 93A, which according to the longstanding precedent of this court and the legislature itself, that the court will make this determination. The defendants make
It's brought under 229A. You said the only authority you have to bring this is under 229A, or 229, excuse me, Section 2.
To recover the wrongful death for an unfair and deceptive act in practice under 93A, you use the wrongful death statute, as we did.
Yes. And the jury determined under 229 Section 2 there was no willful, wanton, or reckless.
No, the jury verdict form does not say, what is your, has there been a violation of 229? It doesn't say that.
No, but
it says wrongful death.
Well, it said, well, yeah, I mean, it says.
And the court, as was pointed out by my brother, in its opinion under 93A, said that this was a wrongful death.
Well, what was the issue
substantive law was brought pursuant to 93A.
What was the issue that the judge had instructed the jury on the wrongful death action? What was the causation issue, apart from unfair and deceptive practice?
Negligence and gross
But
negligence.
it related to the stairs, correct? The condition of the stairs, et cetera.
Certainly.
It's all the same
Certainly.
substantive stuff.
I would disagree with that. I think if we look at 93A, it's in this case, it was Jacob Freeman's unexpected encounter with a hidden and concealed stairway that was built not in compliance with the building code after repeated opportunities, built and rebuilt. Misrepresentations were made for a period of 2 decades to the inspectional services
Right,
department.
okay, all that, but that's what's
It was
tried
his
to the jury.
unexpected encounter with those stairs and the unfair and deceptive conduct that led to that unexpected encounter that formed the basis of the 93A claim, which is the legislature has said is an issue for the judge, not.
No, but the only way you get to that is, I think, is by establishing that there was the action of the defendant was willful, wanton, or reckless. Isn't that what the statute says, 229?
Well, how do we recognize lost chance of survivability?
I'm asking you.
It doesn't fit the statute at all. And the reason why we recognize that claim and we use, under the circumstances of Matsuyama, the wrongful death statute to get us there is because the wrongful death statute is a procedural remedy. We followed the procedure of the wrongful death statute. The only damages awarded by the court, base damages under 93A, are those that are awarded under the wrongful death statute. And
Damages awarded under the wrongful death statute, right? Those are damages
Recognized by,
they're not
right.
93A damages. They're damages awarded under the wrongful death statute?
they are consistent with the wrongful death statute. They are compensatory damages. They are punitive damages. They are the same damages.
Well, they're loss of consortium damages. So you said those are compensatory under 93A. Well, they're certainly compensatory under the wrongful death statute. They're certainly available under the wrongful death statute, right? But you lost on your wrongful death statute claims.
No. We lost under the claims submitted to the jury under the wrongful death
Was an
statute.
act or failure to act by the defendant malicious, willful, wanton, or reckless? The answer, no.
That's right. And the jury was not considering whether the unfair and deceptive acts and practices of these two defendants over a period of 20 years caused some harm to the some legally protectable interest, violated some legally protectable interest of Jacob Freeman, resulting in harm which the judge compensated pursuant to the terms of the wrongful death statute. I'd like to address a couple of points regarding the waiver argument. The defendants had three separate opportunities. They affirmatively, and this also addresses the point about whether the evidence was identical. It was not. In fact, we had evidence taken during the jury trial in which the jury was excused, and we had an entire day of testimony while the jury was deliberating.
Was that on causation?
It was on liability, which is an element of causation. It included the affirmative presentation of Henry Bauer III, the principal of Our House East, in which he argued that there was no noncompliance with the building code. They submitted documentary evidence. None of this was before the jury. There was no suggestion by the defendants that, Judge, we can't have this evidence. We can't have this separate evidence. We have to stop. We have to hold the presses. The only way we can have this case proceed is if the jury is presented with the 93A.
I had thought that there was instruction by the judge that you may find that a violation of the building code is some evidence of negligence.
Certainly, and that's something the jury could find.
So there was evidence before the jury with regard to the violation of the building code. Are you saying it was not presented until after the jury was deliberated?
No. Most of the two claims were presented in parallel. But there was additional evidence presented only to the court and not presented to the jury.
Right, and they said,
that evidence
and
included.
They said that had nothing to do with causation. They say it was wholly unrelated to causation.
I would disagree, because I believe that when you're dealing with 93A, the issue of causation is the 93A causation. Did the unfair and deceptive conduct invade a legally protectable interest? If we are to make a ruling here that in a case where there's an injury, there's a recovery under 93A, and I would submit under the clear and express terms of the survival statute, that injury is recoverable, notwithstanding the subsequent death of the plaintiff. And if we take that circumstance and we say, that's just and it's right, 93A is a statute of broad application. The legislature has applied it to personal injury. It's known about it for years, has not changed it. To suggest that that recovery is permissible, but in the event a person dies, there's no recovery, or notwithstanding the express requirements of the legislature that the decision be made by a judge, and there was ample evidence to support it, that circumstance doesn't apply simply because the plaintiff died as a result of the harm. And this independence of by the court and the requirement that a court make this decision is only preserved if we take the existing 93A remedy and practice and apply it in the wrongful death context, as was done here, using the limitations of the wrongful death statute, using a requirement that the damages and the damages calculated be based upon a degree of culpability. We have that circumstance here. And so we would submit, Your Honor, that this is not even a change in the law. It's an existing 93A remedy that applies without regard. There's no limitation on death, and it would be absurd to think that the legislature meant this comprehensive remedial statute, completely sui generis, applicable to all activity across the Commonwealth, that in the instance of death, somehow the claim evaporates, or the basic rules of the road that we have independent determination by the judiciary somehow goes away. The wrongful death statute doesn't impose a jury trial requirement, and so there's no inconsistency with the application of 93A in a wrongful death context, as was done in this case. And I would suggest it would be grievous harm if the situation that occurred here is left unimpacted or is precluded by a rule that says you hurt somebody, you have a 93A claim. If you hurt somebody as a result of your unfair and deceptive practice, you have a 93A claim. You kill them, you get a pass. That suggestion seems completely absurd.
What is the unfair and deceptive conduct here that you're relying on?
I think it includes a number of facts that span 20-plus years. If we think about it, these stairs were built, the evidence was the stairs were built in the early 1980s, completely without a permit. In fact, the testimony of Patricia Moreland-Levins indicated, who does the books for both defendants and had substantial responsibilities for complying with building permitting issues, referenced that $140,000 worth of work was done in 1984. There's not a single building permit issued to these defendants for this premises anywhere in up to 1984.
So how is that unfair and deceptive?
The building code provides a circumstance where the legislature has identified an issue that says if we're going to have buildings that comply with the code, it starts with the submission of a building permit.
Yep,
and if you don't do that...
But how is that unfair and deceptive? Because otherwise, Chapter 93A will become the super remedy that replaces all other remedies.
I would respectfully disagree. I think the courts, the trial courts have shown tremendous reluctance to apply it broadly. It's only in the special circumstance, but I really wish to address this idea that what the unfair and deceptive act in practice was. When a person walks into a place of public accommodation, a commercial enterprise, they have a right to assume that basic issues of construction, of law are followed. These defendants illegally constructed this stairway.
But how is that unfair or deceptive?
Because the interest of a patron in the bar confronting this dangerous condition, he is entitled to assume that the landowner has complied with the requirements of law. And so it's unfair and deceptive when they haven't. In addition, we have actual affirmative misrepresentations by the defendants to the building department regarding what they were doing. And one final point. If we look at the circumstances here, after the Judge Fahey's ruling, she notified the defendants that they were obligated to tell her whether to report her findings to the Inspectional Services Department and to see and to confirm that the building was up to code. If you go there today, there is an enclosed, self-closing door at the top of the stairway that would have precluded this harm. And that matter is before you in the record. It's at the record appendix, page 1153 to 1164. And so we'd submit, Your Honor, that Judge Fahey's decision should be upheld in all respects.
Thank you.